Welcome to Inherently Distinctive.
Welcome back to Inherently Distinctive with attorney Mark Goodman. Mark helps entrepreneurs and inventors protect their ideas through patent and trademark law. I'm your host, Sophia Morales, and today's episode is Can You Trademark a Slogan, Sound, or a Color? What Entrepreneurs Need to Know. So welcome back, Mark. It's good to have you back.
Oh, it's good to be back here.
I've been thinking about Sophia's widgets, and I have some questions.
Okay.
So what kind of things can be trademarked beyond just names and logos? Can you really do like a sound or a jingle?
So
Like
you actually can get trademark. I mean, think of what's your favorite jingle, whatever you can think of, right? I mean,
I'm in.
Right. Even like the famous NBC chimes, ting, 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 right? On NBC,
The
it's
peacock.
trademarked, right? You know, I think they use a word like the McDonald's run, ba-da-ba-ba-ba. Pretty sure that's trademarked as well, right? So, you know, sounds can be trademarked. Also, catchphrases, right? So use this example all the time, right? Nike has the trademark to the name Nike to the phrase "just do it," for example, and to as well as the swoosh symbol, right? So you've got a name, logo, and a catchphrase, right? So those catchphrases can be pretty important sometimes. I do a lot of trademarks on those as well.
Is that something that you can? I'm just gonna trademark all of this, or is that individual acts that have to happen there?
So each of these are discrete applications, right? Because the trademark, first of all, the trademark office has to evaluate each one of these things on its own merit as compared to potential conflicting marks, as well as compared to, as well as the legal standing as a trademark for each of these things, right? And so, no, you can't put it together. Here's a common issue that I run into a lot, though, is that you'll have a logo which also has the name in it.
Yeah.
Okay. So get this question all the time. So this is good to deep dive into, right? Which is, okay, so people say, well, can't I do it all together? And I say, well, you can, but what you're doing there is you're just getting a trademark that is the name and logo together in this way, right? In this stylized version of the name, right? You're not getting what you probably want the most, and what I think for at least most entrepreneurs is the most important mark, which is the name itself in just text, right? Because that's by far the broadest with respect to someone infringing the name, right? So when you think about this name and logo infringement, so couldn't this be together? Well, just think about what happens if you have to enforce this, right? Well, if someone has a name that is the same or similar to your company's name, well, you're going to go after them on the trade name registration that you have, hopefully, right? If they have a completely different name, whether or not your name is part of the logo, but let's say the logo design is eerily similar to your logo, right? And they're a competitor in the same industry. Well, you're going to want to go after them for the infringing the logo trademark. And same thing, if you have a catchphrase, right? If they're using the same catchphrase to advertise their products and causing some confusion there, well, you need that trademark to go after them, right? So there isn't really a shortcut. So trademarks are basically a process of building this war chest, right? Of trademarks. Early in your company's existence, it's going to be probably just the name and logo or name, logo, and catchphrase. And then you're going to have names of different products as you expand it out and develop more products. And then you may have things like sounds and other things that we can talk about as well as this thing builds up.
So, question for you. I've heard of this concept called trade dress. How is that different from like a design patent?
Okay, great question there, right? So trade dress and design patents, honestly, there's a lot of overlap here in terms of what you're covering and what you're doing. But I guess I look at it as just an opportunity to have extra protection here, right? Because there'll be scenarios where the design patent would cover a certain infringement, maybe trade dress wouldn't, and vice versa. but let's understand them first, right? So a design patent is a type of patent application that covers the industrial design of a product, typically, right?
Okay, my
So
widget, for
right. So let's
example.
say the widget has this beautiful shape to it, right? Just imagine the shape of a Corvette, for instance, right? Let's say somebody else created a car that looked exactly like a very popular Corvette, right? But I mean, hey, we're not infringing here because we're not calling it that. We don't have the same logo or anything like that. It would still be infringing because you're infringing the trade dress, right? Like if we were to also sell a cola and it had that hourglass shape of a Coca-Cola bottle, that classic shape, we very well could be violating their trade dress as well. Um, and in each of these cases, there's overlap because you could file a design patent application that would cover this design, and you could also own trade dress protection, which would cover the same kind of design. But they're doing it in a different way. So with respect to your design patent, it's just basically saying this is my invention, right? I invented this design of something and you're now infringing it. And so there would just be a comparison as to the product, whether the infringing product was identical enough to be covered by the design patent. By contrast, on trade dress, the question would be, are consumers likely to be confused as to whether or not your company is them or their company is you, right? And again, I think this collapses a lot, right? There's a lot where it's the same. The trade dress protection in some ways is better because it lasts so much longer, right? Trade dress could last forever. A design patent would expire after 14 years, right? It's even shorter than a utility patent application.
So you
So
could really have both things. Is that what I'm hearing? You could
yes, you can
have
have
a
both.
design patent on your Coca-Cola bottle shape, and then you could also have trade dress on that
Yeah,
shape being presented.
right. So, and excuse me, I think I misspoke. Design patent's 15 years.
15 years.
But
Okay.
still, I mean, that can go by faster than you
I
think
was
if
going to say
you're a larger
that's
company.
not very long.
Right. Yeah.
You're not even getting your toddler to college yet.
No, not yet. But the ornamental design is often very, very important, right? I mean, think of how much Steve Jobs put into just the design of just the shape of like an iPhone compared to other phones.
Hmm.
Put a ton of effort into that, right? It's, it definitely matters out there. One thing to understand about both trade dress and design patents too is that there it's funny because you can't get those protections if the design element is utilitarian also. So this can be a pitfall that you might have to think about how to work around in some instances. So for instance, if let's say there's some lever that comes out of your widget and that lever is a great handle, but it's also beautifully shaped. The
Hmm.
law will take the position that you can't get trade dress or design patent protection to this beautiful lever because it's also a lever, right? But if it's just a lever, the actual, let's say the fact that there is that lever coming out, right? But if it's just okay, there's a lever there, but this lever, the way it's shaped is beautiful. You could protect that, right?
Okay.
Just
Yeah.
not. But if there's no way to design it differently to avoid the aesthetic problem, then the law will say no, you don't get protection to that.
Interesting.
It can be,
Yeah,
you
it
know,
seems like it could be a little arbitrary.
it's murky, but it's
Yeah.
understandable. You have to think of it in the point of view of say someone's trying to compete in this field, right? If you have a utility patent, okay, then you have the right to own that invention, right? That utility. Okay, so that's clear. Stay away from that, right? But if all you have is either design patent, trade dress protection, other people are supposed to be able to compete with that same product's utility. So as long as they can do that without violating the aesthetic, then you still get the protection on the aesthetic. But there are some instances where you can't. They're like merged together. And in that case, unfortunately, you can't use a design patent or trade dress to substitute for a utility patent. That's really the fundamental thing courts are looking at if this gets fought.
So when it comes down to, well, this is going to, I think, come out of trade dress a little bit. Can I trademark a specific color, for example, that is associated with my company? I'm thinking like the Ferrari red, for example, or the Bianchi blue that they put on their bikes. Is that protectable?
Yeah, let's talk about colors with trademark. That's a good topic. You can't necessarily just completely own a specific color for any purpose, right? But if a color is highly associated with your product, you can claim trademark it in that color, right? And it would be limited, of course, to your industry, because obviously you're not going to just own a color completely for
Yeah.
all industries, right? But just imagine that kind of shade of brown that UPS uses, right?
Yeah.
If you were to start a parcel service and even if it was a different letters, different name, whatever it is, and have that shade of brown, I think you're getting sued, right? That was the first example that came to mind here with the color. Now, it might be different in different industries, right? The Corvette red, well, maybe if there's a very specific shade of red that consumers associate with a Corvette, maybe. I'm not sure whether that's true or not, right? So you'd have to be able to prove that that's true.
Yeah.
But if it is, maybe. But typically, I think with cars, I mean, there's tons of different colors and lots of shades of red that are used. That might be a harder case there. And I think this just reminds me of another topic with respect to color and trademark. When you file a trademark application to a logo, they will ask you, do you want to claim color as a feature of the mark? Okay. This is always something you have to think about, right? So if you claim color and then the mark will include, and when it's published, it will include all the color, right? And if you don't, it'll be like a black and white grayscale image that you'll have to present of your logo design, right? So what do you want to do? So the answer is actually, if you wanted to have the most complete trademark protection possible, you would do both, right? You would have an application, and larger companies do this all the time, where they'll have the logo filed with all the color, and then they'll have one that's just a black and white and doesn't claim color as a feature of the mark. Now, for our small business and entrepreneurial clients, sometimes that is like, oh my gosh, we're getting this trademark bill too high, right?
Yeah, exactly. We've just taken what I thought I was going to spend and multiplied by 5.
Right. So here's how I approach it is a couple things. In general, my advice is let's do the application without a claim to color. Because that's I feel broader, because it doesn't matter what colors other people are using. We're just trademarking this design of the logo. Okay. And then maybe later, if the company bill really takes off, let's also add another application with the color scheme that we're using here. Now, the exception might be, though, that let's say you really are set on a color scheme and you think that color scheme is going to be a big part of your brand. Maybe the color one is a higher priority, right? And again, to understand the difference, I would always imagine this. Imagine 2 plots of land that are mostly overlapping, but at the edges, they're not overlapping, right? There's so different kind of shapes. Like one is a simple example is a square and a circle on top of each other. Well, they're gonna, in some parts of it, the corners, the square will cover more. In some parts, the circle, let's say, goes around the outside of the edges of the square, it's gonna cover more than the square in that circumstance. That's how I feel about a color mark versus a black and white mark, if it's the same logo, right? And so in the instance where, let's say, you have a really specific color, let's say, because think of an infringer that might be out there. If the infringer has changed the logo design a little bit, but the color scheme's totally different, you're going to want to go after them on your black and white registration, right? Because you have more scope there. Doesn't matter what the colors are. This logo design is too similar. Sorry, you can't do this. On the flip side, let's say your infringer has somewhat significantly changed the logo design. It's still a little too similar for your comfort, but it's like, all right, isn't exactly the same. But let's say their color scheme is dead on, and consumers are going to see those colors coupled by the similar logo and be confused. Then you're in a better position with your color registration. So
Okay.
there you
And
have it.
if I start with one, it doesn't stop me from adding the other one later.
Does not, no.
All right.
Okay.
And are there industries that benefit more from kind of these non-traditional trademark sort of approaches?
I would think, I mean, just my off the cuff answer here, without having researched this kind of topic thoroughly at all, is that I think consumer based businesses, this type of thing would be more important, right? Whereas maybe B2B would be more about the name, logo design, because consumers, like just seeing a certain color instantly, oh, okay, I see that brown, that's UPS, right?
Yeah.
I see that red, that's Coca-Cola, right? And you might not even be focused in on it as much. Or I hear a certain jingle, oh, I know what that, I didn't even have to look at what product this is, right?
Right.
I hear the jingle and I instantly identify with what's going on, right? So, and these kind of things like jingles, for instance, are much more common, I think, on consumer advertising versus business to business advertising. Could be wrong on that, but that's my sense.
So, what is the process like if you're trying to file for trade dress or a sound mark, for example? Ba, 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 ba.
It's similar if you're filing, except you just have to upload. There's a little bit more to it in terms of the application, but you can upload the sounds, you can upload like pictures or drawings, have drawings made of the thing that you want to have covered by trade dress, for instance, right? And that's really it. Most of the rest of the stuff is the same, but just got to present that in a different way, right? It's not just, hey, this name, right? It's
Right.
okay, we're now giving you this sound, we're giving you this a drawing of this that we want to protect.
And what is the most unique trademark you've seen that people wouldn't really think of as a trademark?
So this goes back to an old case that I learned about in law school, actually, right? And it was basically a trade dress lawsuit between different restaurants.
Hmm.
And there was an argument about, okay, you're copying just the design of our restaurant, like how the chairs and tables and everything look. And that's causing consumer confusion, and you're violating our trade dress in that way. I was like, really? Quite frankly, sitting here, I don't remember how that went either to the appeals court level or the U.S. Supreme Court. Maybe we'll follow up on the next podcast on exactly what the name of that case was and what it was. But the fact is, it got to the Supreme Court level on that. And when you think about it, even though at first blush, I'm like, what? You're talking about chairs and tables here? But it kind of, I mean, just think about, and this wasn't the case, but just think about being at like In-N-Out Burger, right? The way the garbage cans are, the way those tables and chairs are laid out. It just has this instant, like you can walk into an In-N-Out, you haven't seen the signage, you don't know you're in it, but you would walk in and you would, if you're an In-N-Out customer, which I have been, right? You'd be like, wow, this is In-N-Out, right?
Yeah.
So that's the kind of the sine qua non of trademark, right? Is that instant consumer identification. So even though at first blush, I was like, wow, really? We're doing that? But it's understandable
Yeah.
when you really think about it.
I can see that. Well, thank you for all your insights on this today, Mark.
All right, no problem. Anytime.
You've been listening to Inherently Distinctive with attorney Mark Goodman. To connect with Mark or learn more about protecting your business identity, visit goodmanlawnevada.com and make sure to like, subscribe, and leave a review. And we've got more good topics coming for you down the road, so stay tuned.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.